Good morning. Thank you for joining us today. I'm Lydia Chartray. I'm a partner at Husch Blackwell on the Condominium and HOA law team. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We're going to try to answer all of your questions today, but in case we don't get to them all, we will answer them by email, and that will follow the presentation today. A PDF of the presentation is available in the Program Materials folder. This program is pending approval for Wisconsin Continuing Education Legal Credit and has been approved already by the Community Association Managers International Certification Board to fulfill continuing education credits for CMCA certification. To report your CMCA hours, you can click on the CEU icon at the bottom of your screen. A certificate of attendance will be emailed to you later on, along with a recording of this webcast for watching and sharing. Toward the end of today's program, please be sure to complete our short survey. We do use your feedback for future program planning, so we can make sure that what we're presenting to you is applicable to your association. That's it for all of the housekeeping items, so we can get started with our program. What's new in 22? Today, we're going to cover what's new with the Fair Debt Collection Practices Act, with collections in general, and also the new mortgage underwriting requirements that are giving everybody such a headache. So joining me today are my partner, Dan Miskey, who along with myself has been admitted to the National College of Community Association Lawyers. We're also joined today by our three paralegals, two of which you're probably familiar with, Sandy Chapman and Billy Fothery. But it is my great pleasure to introduce our new paralegal this morning. Her name is Brenda Zach, and I'm going to throw it over to Brenda now, and I think that she's going to introduce herself a little bit better to you. So take it away, Brenda.
Good morning, everyone. I said my name is Brenda Zach. I am new to the Condo and HOA law team, but I am not new to Husch Blackwell. I have been with the firm since 2017. As far as education background, I have a paralegal certificate from Milwaukee Area Technical College, and I have my Bachelor's of Arts from Mount Airy University. Prior to coming to Husch Blackwell, I worked at a debt collection law firm as a legal assistant and a paralegal, where I successfully negotiated accounts that I resulted in the collections of over $6 million recovered for clients. So I do have experience in helping you get your money collected. I have knowledge of the Fair Debt Collection Practices Act and the Consumer Financial Protection Bureau, as well as the new Regulation F, and I will be implementing those rules and regulations when communicating with debtors. I also spent time as a deputy court clerk / judicial assistant for the circuit courts. So I have experience on the other side of the legal world as well. Since I have been at Husch Blackwell as a legal assistant, I was working in different areas of labor employment litigation and real estate. So I have had experience in a few different areas on top of what I am now doing with the Condo and HOA law team. So at this point, I am going to just turn it over to Attorney Dan Miskey, and he will continue on with the presentation.
Thank you, Brenda, and we're so happy to have her and obviously our other two paralegals, Billy Fothery and Sandra Chapman, who almost all of you know, and who do such a great job for us. So we're starting with the Fair Debt Collection Practices Act, and do you know about Reg F? And for those of you who don't, here's the simple answer. It went into effect November 30th. And if you don't know about Reg F, you need to know about Reg F. And it covers as much of the Fair Debt Collection Practices Act as you could possibly imagine, because how else, other than our United States government, could you possibly have a situation where you have a 20-page statute and the Reg F that comes out roughly 40 to 50 years after the statute it was initially planned, obviously much sooner, is 600 and some pages long. That's in legal world, that's just what you would expect from the government, but it sure seems an odd way to do things. So having said that, let's just get into what you care about. So the Fair Debt Collection Practices Act, the Consumer Financial Bureau, Protection Bureau, and Reg F is the final debt collection rules that apply to the Fair Debt Collection Practices Act. That's just generally. Why you must care. Well, you didn't before because it really didn't apply to property managers unless you did something that was, you represented yourself in some fashion that you weren't, or you took advantage of things you shouldn't have relative to like copying an attorney's collection letter and using it as your own. Those types of things is how they found their way into trouble. Not so much anymore because consumers can now make demands on the original creditor, so therefore the association, and then hence by definition on the managers who are collecting on their behalf. So now you've got to at least have some understanding of what's going on Reg F. Regulation F, for all practical purposes, though, is still the Fair Debt Collection Practices Act. It's just the regulations on how it's going to be applied. Is this abusive? I just love the picture. Let's be honest. The basic answer, though, is this. Abusive is what I care about in this act as it applies to, or harassment as it applies to consumers / unit owners / residents of associations. And therefore, because that's what we care about, because that's where I think you're ultimately going to end up seeing some potential liability, it sort of works like this. So we'll get to why I care about it. But I wanted, this is one other change. Pardon me. A consumer now includes deceased persons. Actually, that's a good thing because now it lets us as third-party collectors actually talk to, let's just say, the administrator, the personal representative, the executor. It lets us talk to them as though they were still, the person was still alive without having to be concerned about Fair Debt Collection Practices Act violations. So from that standpoint, this is maybe one of the few things in here that's actually good for people who collect against consumers. Communications, it's always been 8 a.m. to 9 p.m. You'll notice now consumers' local time is prohibited. So then I added in red, how do you know? How do you know when you call a consumer that it's 8 a.m., 9 p.m. consumers' local time if they're a unit owner who lives in Florida? Well, you go, okay, it's 1 hour time difference. Well, you better be right. You better be right that it's 1 hour. What if they're in California? What if they're in Hawaii? What if they're in Europe at the time you happen to call? Consumers' local time would create a problem. I think it'll end up being based on what you would have reason to know or believe. But it sure makes it, maybe you better not call other than from 11 a.m. to, let's just say, 5 p.m. so that you give yourself a whole bunch of leeway there. Inconvenient places. So that was one of the things that became interesting. The other one was the consumer's place of employment. The basic answer is you can't communicate with them at the consumer's place of employment unless they sort of tell you you can communicate with them there. Pardon me. So the goal here is look at the email. If it looks like an employer email, you may not be able to communicate with them there. And hence, our basic advice is don't communicate with them there because you're going to create a problem. Your safest route is to send them a letter and go, if you want us to communicate with you by email, send us an email saying we can communicate with you by email and at what address. But of course, keep in mind they can always cancel that. And therefore, then you can't communicate with them. So even though you thought you could, now you can't. So it makes it really hard to communicate by email because it can always be taken away. Which is what this essentially says. If the consumer refuses to pay or asks you to cease further communications, you've got to stop. If they ask you to cease a mode of communication, you have to stop communicating within that mode. Now you would argue, but the Fair Debt Collection Act doesn't apply to us, and therefore I don't have to worry about this because I'm a manager, or I'm the board of directors, or I'm whatever I am. Yes, but probably no. Because although the Fair Debt Collection Practices Act may not in this sense apply to you, the harassment provisions of the act also don't apply to you, but the Wisconsin Consumer Act does apply to you, and it prohibits harassment, and the federal act sort of suggests this type of activity is harassment, which it is. It would seem like not a far stretch to see it pushed to that part. So, email communication, ways notice of consumer's email may be received. So you'll notice I have in here creditor. That's you. That's the homeowners association. That's the manager. Okay to use email if consumer hasn't opted out or creditor sent the consumer notice making certain disclosures and giving an opt-out period. You're not going to generally do that. So my basic answer is going to be don't email to a business address unless you get their okay that you can email to their business address. That's the one that concerns me, just so we're on the same page here. Obviously, a new law, no cases out there yet, but it's not going to take long. Text messages. Here's my basic answer. Don't text. You're just asking for problems because you're going to have a hard time proving you gave the notices that are required to be given and the rest of how this works. Voicemail messages. This is where you get into a problem. If you do nothing else, copy this language, obviously changing out Billy Fothery's name and Husch Blackwell and the phone number for yours. But this is the concept. This is literally the words you must say and no other words if you're leaving a message relative to collection. And once again, I have the same fear here. If you leave a message as a creditor different from what this voice message is, the argument is going to be whatever you left amounts to harassment, and therefore you are subject to the Wisconsin Consumer Act, and therefore you violated it, even though you didn't violate the Fair Debt Collection Practices. Here's the magic language: harassing, oppressive, or abusive conduct. You can see this is going to be, as I've written, full of landmines. So get ready for the next wave of suits. And here's why. If you contact the debtor, if we contact, I should say, not you, 7 times in 7 consecutive days, it's viewed as harassing. Remember the part about everything that says harassment, just remember Wisconsin Consumer Act applies to you and it doesn't define harassment. Or if the consumer calls the consumer, this is any person, this is the consumer, this is the unit owner, this is anybody but the unit owner, well, and the unit owner, which essentially means you can only call the unit owner 1 time every 7 days, unless he calls you and then you call back once, not worth the risk. So that's the problem that now exists. And everyone in the country is trying to figure out how to deal with this problem. And the answer may well be hidden somewhere in the 600 pages, but it's not really. It's just, there's going to be a new normal. I don't think everybody's figured out exactly what that's going to be yet. There's no exception for attorney involved. We already knew that. Defendant consumer except with prior consent. There's not going to be prior consent. Or what it's really saying is you can't cure a problem that you caused by getting their consent later to whatever your prior problem was. So if you violate, you're at risk. We kind of know if you've been involved in any FDCPA litigation, they all start at $7,000 to $10,000 as a settlement offer because they've had to do so much searching and researching. I think it's all a lie, in my personal opinion, because they really don't. They file the same complaint every single time in federal court, it seems to me. So, but it is what it is. If you're tied into one of these suits, it becomes a pain in the butt. Time-barred debt. This used to be a little more free, meaning you could try to collect debts, sort of, that were past the statute of limitations. At this point, if the statute of limitations have expired, I wouldn't even try to collect it in any fashion. It's just not worth it. In other words, if you're going to go after someone, go after them within the statutory time limits. If you want to have a lien on a condo or in a homeowners association, meet the requirements. If you want to sue them for breach of contract, you've got a 6-year statute. Obviously, for condominium lanes, you've got a 2-year. For HOA acts, you've got kind of like a 4-month. We're trying to get that changed. We keep working on that issue. It's just a hard issue because it's not something high on the legislator's list. Validation notices, the same mini Miranda has now been expanded. It gives the consumer all the defenses. It tells the consumer how to dispute a debt. It makes it really easy for the consumer to contest the debt. And you give them a form in which they can mail back saying they contest the debt. So it is really easy. Relative to what the expansion of the act now requires, an itemization date, an amount of the debt on the itemization date. So this one's key. I don't believe a debt collector. I didn't believe it before. Now I'm 99.9% sure because, like I said, there's no cases. But nationally, everybody who's talking about this goes, you cannot rely on the creditor's calculations anymore. In other words, you can't rely on the associations, or if you're the collector, you can't rely on the manager's calculations. You have to know that debt amount is right. You have to have an itemization of the debt. That's why we prepare all those ledgers we prepare, and you got to know the current amount of the debt. All of that's got to be stated on the initial notice. And the itemization date is where all the problems are going to seemingly start showing up, because it's got to be one of 5 dates. The last statement date, okay, that one's easy if you've got, you know, a statement that you send out. But let's be honest, most associations don't send out statements, so that doesn't apply. A charge-off date, well, most of you guys don't charge off debts, so that one doesn't really apply. Last payment date, okay, that one's pretty easy to figure out, assuming you've got a payment date, assuming we can put it onto the ledger. Transaction date we struggle with because we can't figure out if it would seem like the transaction date is whatever date you normally would add assessments to the current month. So most of the time, let's be honest, 1st of the month or 10th of the month, depending on how your documents read, probably 1st of the month. So that's what we're going to be using as the transaction date, but the last payment date is probably the safest one, assuming obviously you've got all the records. I don't think anyone will argue that the last day that an assessment was due as the transaction date isn't actually a date. Judgment date really doesn't apply until you have a judgment. So that's not it. I know I'm probably close to my time here. So we are on my last slide, the practical implications. I just want to make sure I re-stress these for everyone. Harassment, 7 days, 7 calls, 7 days, or calling the consumer says stop, or calling the consumer once a week. Because remember, this is any person, the consumer gets 7 days. Time-barred debts, don't seek to collect them. Avoid communicating with the consumer at work. That was for us, but it's actually for you guys as well. I should have added a C here for you guys, so we covered that. The validation notice, it's completely different than it used to be. You have to use their form. This is going to be easy pickings if you are not in the debt collector world, so make sure you are. And that must be right. So you got to recalculate the debt. That is it from my and so I will pass you back to Brenda, Sandy, and Billy.
Hello, everyone. Brenda taking back over here. Sandy and Billy and I are going to over collections, 5 things that help your associations actually get paid. I'll be started off. First, you need to use a law firm that knows how to collect condo and HOA assessments. Collections attorneys that specialize in HOA law and can pursue the best remedies allowed under your governing documents and the state law. Your association needs to be able to measure the success of the collections. Does your attorney provide statistics on what they cover? Because they should. We are able to measure the success. We collect the interest, we collect your attorney fees, and we're able to break that down and show you. Also, you need to know what you're spending and recovering. We track each collection success. We have a proven collection strategy. Since 2012, our team has collected over $16.3 million in dollars. You also need to be sure to have a collection policy and make sure that you follow through with it. If you don't have a collection policy, you should get one. You also need to make sure that when your account, if you're 60, 90 days past due, send it to the attorney for collection right away. Don't wait. Once the account's with the attorney, do not have any further discussions with the owner, and make sure that you lock them out of any online information. You don't want to be giving them a wrong balance. You also need to know that if the owner calls you, they want to discuss the debt, just send them back to the attorney. This way, we're the bad guys. The board and the property manager don't have to deal with them. You just send them to us and let us be the bad guy. That way, you have to continue to work with these people on a continued basis. You have to live with them. Just send them to our office to deal with. So we really just need to stress that once an owner's in collection, don't have any further communication with them. Don't talk to them about the outstanding balance. Just say that your account is in collections and forward them to the collections attorney that knows how to handle their account. What we really just want to stress to you, don't talk to them, send it over to an attorney that knows what they're doing, and just know that we really have our goal is one of two things. We either want to get you paid or get you a new paying owner as quickly as possible. So that's why we really want to just stress these policies and having them set into place. So now I am actually going to turn it over now to Sandy, who is going to talk to you about the next process.
Thank you, Brenda. Great job. This is Sandy Chapman, and I'm going to talk to you about another way of possibly collecting your debt. The mortgage moratorium is now up, and will start getting served with more foreclosure papers. When you receive those, by all means, send them to an attorney that knows what they're doing and how to monitor that foreclosure action. We've had multiple cases where the owner has gotten paid and the association has been paid through a mortgage foreclosure by surplus funds. And this is important to know because a lot of times we throw up our hands and think that there's nothing we can do and we're going to lose out. But I have seen many cases in the last few years where there is a low mortgage, but the mortgage company hasn't been getting paid, and this is what's happening. And so we file that notice of retainer and claim for surplus with the understanding that if the bid price paid is more than what is owed to the bank, the association is next in line to receive those funds. And that's something good to know. So that's your first choice. It's also nice to have it monitored because a lot of things can happen in a mortgage foreclosure. You can either, the case can be dismissed, it can be delayed, they reach an agreement, refinance the loan, lots of those things. And in your mind, you still think it's in foreclosure when it actually isn't. We monitor those things and then keep the board and the property manager aware of what's going on and what the status is, and then provide them with options and how best to serve the association's best interest. So never hesitate, and you should always send any mortgage foreclosure papers to the attorney and have that mortgage monitored. And now I'm going to pass it over to Billy, who's going to talk to you about other probabilities.
Good morning. I'm going to talk a little about some things that can kind of be hiccups in the collection road. And one of those is bankruptcies. And before we even get to the point of bankruptcy, it's really important to get us debts early. We always say 60 to 90 days past due once their account is 2 to 3 months behind. Get it to collections immediately. Not only is it easier to collect and less likely to go to bankruptcy, then it's easier to pay off 3 months of dues than it is to pay off a year of dues. So always get that to us early. Then too, we have a chance to get a lien in place before any debtors could possibly file bankruptcy. And that gives us one of our best tools to combat that bankruptcy and make sure that the association gets paid in full through that bankruptcy plan. We found that the debtors are getting more sophisticated, if you want to call it sophisticated, sneaky, however you want to phrase it, in how they are filing their pleadings in the bankruptcies. We are finding that more and more are trying to strip our liens, which means that the association doesn't get the same protection as a secured creditor in the bankruptcy. So we always stress that get us accounts early, and the second you get served with a bankruptcy payment, get that to your attorney. There's timelines that start ticking, and once those timelines are done, the options for the association are done as well. So it's very important to make sure that you get a bankruptcy notice, that you get it to your attorney so that they can handle it. Another thing that comes up is an owner dies. A lot of times an owner dies and no one knows what to do, or they just let it sit there until someone contacts us. They get promises from a family member that something's going to happen and nothing materializes. So again, the association has options when this happens. And we just want to stress that, again, having a law firm that understands condo and HOA law can best protect you in situations where an owner dies. A lot of people, unfortunately, die and they don't have an estate. They don't have a will. There's nothing filed. Nothing ever goes to probate court. There's no one, you don't know who is supposed to pay these dues now. So there's things that we can do for the association in situations where that happens. If there's an estate, we can file a claim against the estate. If there's no estate and no one stepped up to pay the assessments, we are also able to proceed with collection as normal. What we do is get a special administrator, which is just someone to accept service on behalf of that deceased person. So again, when an owner dies, you have rights, you have remedies. Make sure that you get it to an attorney that knows all of that and can best protect the association in those cases. You don't have to sit around and wait for someone to step up and pay. So that's the number one thing. You don't need to sit back and wait. And we will hand it over. Oh, I have one more. Little shameless self-promotion this morning. Moral of the story. Hire a law firm, hire Husch Blackwell, who knows we have the only two CCAL attorneys in Wisconsin. Again, shameless self-plug this morning. But we really do know what is what with condo and HOA law. And you want to make sure that you're using an attorney that knows all of that and can best protect the association. And with that, I will turn it over.
Thanks, Billy. So now that we've got your head spinning from collection and what's new with FDCPA, we're moving on to the next big headache for everybody right now. Forgive me for this, but we need to talk about that new lender questionnaire and what we do with it. Property managers out there, self-managed boards, I'm sure you have noticed that the lender questionnaire all of a sudden got much longer. And it's not the length, I guess, that's really the concerning thing. What's concerning is some of these questions they're now asking are really posing some difficult challenges for association boards and managers to answer. And for those of you not in the know, what we're talking about is oftentimes when condos are bought and sold, lenders require that the association fill out a questionnaire, and it's gotten different. So we're going to talk about what's different, what's new, and how we handle it. So what are these new lending requirements and why do we care? Well, basically, following the collapse of the Champlain Towers South condo in Surfside, Florida, Fannie Mae and Freddie Mac put out new lending and underwriting guidelines. And we care because as of 2020, 62% of conforming mortgage loans were owned by Fannie Mae and Freddie Mac. And I even saw a figure that it got as high as 75% of all conforming mortgage loans in 21. So the point is most mortgage lenders have to follow Fannie Mae and Freddie Mac guidelines, and hence they have to use these new, longer, dreaded lender questionnaires. So we all have to deal with it across the nation. Who do the new lending requirements apply to? Well, according to Fannie Mae and Freddie Mac, these new underwriting requirements apply to all mortgages secured by units and projects with 5 or more attached units. So practically speaking, we're talking about condominiums. We're not talking about single family home subdivisions or HOAs. So you guys are off the hook for now. What are they asking us to provide in the questionnaires? 3 key categories. One is significant deferred maintenance and unsafe conditions. They're asking about that. If those are present in your community, that may be making you ineligible for lending until the repairs that are needed are complete. They're also asking about special assessments. Lenders need to know the reason for the special assessment now, and they need to evaluate the total amount of the assessment and the payment terms that the association has put out for the owners. And finally, they're asking more about reserve requirements, and you must contribute 10% of your annual assessment income to reserves in order to be considered eligible under the new guidelines. So all of this has everybody in a tizzy asking themselves, are we ineligible for lending? What is significant deferred maintenance? Well, of course, they don't give us a definition, so we have to sort of piece things together. They give us some examples of signs of significant deferred maintenance, which include a recent full or partial evacuation of a building, any defects or damage or deferred maintenance that has the effective impact in the structure, safety, soundness, habitability of the building or the units. If you've got property improvements that need substantial repairs, if you have anything that impedes the safety or soundness of structural components within your association, like your HVAC systems, electrical, plumbing, foundation, roof, load-bearing structures, all of these things are going to lead to red flags, essentially, for the lenders. And there's no real bright line test for this. It's kind of a smell test. You know it when you see it, that kind of thing. So what do they need to know about your special assessments? Well, it used to be that they just wanted to know if the selling unit owner was current with special assessment payments or not. And that was a pretty easy question to answer. Now, lenders have to document for underwriting a few things. The reason for the special assessment, the total amount of the special assessment, and they have to document that there's going to be no negative impact on the financial stability or marketability of the condo project as a whole because of this special assessment. Basically, they're saying the special assessment isn't going to bankrupt everybody. The lender also has to consider the outstanding special assessment liability for the individual borrower, what that means for the individual's financial position, and they include that special assessment in the individual debt ratio analysis for the loan. Also, if the special assessment is related to structural integrity, safety, soundness, habitability, then the project that's being funded by the special assessment will have to be completed before the condo is going to be considered eligible for lending. So keep that in mind. And finally, the reserve requirements. What used to be a guideline, 10% contribution of assessment income to reserves, is now mandatory. And your financials need to clearly show that 10% of your assessment income is put into the reserve account each year. The form is going to ask you if you have a reserve study. It's not required at this point, but I would say it's definitely highly recommended, and we'll get into why. How do we answer the questions? I mean, that's the key right there. They're tough. I mean, most of them require a crystal ball at a minimum, and some of them I think actually require a law degree to answer some of these things. I mean, here's an example of one of the questions on the form. Are there any outstanding violations of jurisdictional requirements, zoning ordinances, codes, etc., related to the safety, soundness, structural integrity, or habitability of the project's buildings? And is it anticipated that the project will in the future have violations? Really? I don't know. How are you supposed to predict the future? Another question, is the condominium aware of any deficiency to the safety, soundness, structural integrity, or habitability of the project's buildings? Are we aware of any deficiencies? How are we going to know? But we do have to come up with an answer, because if we stop filling out these lender questionnaires, then no condos are going to get bought or sold, and we won't have marketability, and it's going to cause bigger problems. So we do need to try our best. So here's what you do. First, only provide answers that you know. Don't guess. If you have to put a not applicable because something doesn't apply to your condo, go ahead and do so. When the form asks about structural conditions and deferred maintenance, it's okay if it's not a simple yes or no answer, because really it's the lender that's supposed to be doing their own analysis on this. So the association's job and the manager's job is just to provide the lender helpful documentation, like your reserve study, for example, your reserve schedule, how we're funding the reserve, any recent building inspection reports or structural engineering reports. If you have them, provide them, because that will help the lender do their job. You can also consider asking the unit buyer and seller to sign an indemnity agreement, which would indemnify the association for any negative effects for the information that the association has provided or did not with the lender questionnaire. CAI put out a pretty good indemnity agreement example, and I'm including that with your program materials today. So take a look at it and consider it, and talk to your attorney if you think it might be something you might want to implement with your association with these questionnaires. Again, CAI has been helping us out with how to answer these questions. So if you feel on a particular question you don't have the expertise to answer on some of the structural type questions particularly, I'm not going to read it to you, but CAI put out this recommended response. You can copy and paste it if you'd like. I think this one is pretty good too. It's just basically saying we haven't gotten any information about this, but hey, lender, it's your job to investigate, so go have at it. But we're just saying we don't have any information at this time. So the big question everybody's asking too, is this going to be around forever? Is this the new normal of lender questionnaires? And as I put this program together, these underwriting guidelines are still considered temporary, but apparently the feds are trying to push to make them more permanent in the coming months. So we'll see how that develops. CAI on the national level has been very active with this, as they are with many things, thankfully. And they wrote a really good letter to the Federal Housing Finance Agency in February, requesting that the temporary guidelines actually be suspended for a while, at least for a year, to allow associations to assimilate and gather the information that they need, kind of get used to this, because people are starting to get turned down for lending and it's hurting the condo market, and associations need time to catch up and figure out how we're going to be answering these questionnaires adequately to get this lending in place. So hopefully that didn't fall on deaf ears. So putting the questionnaire aside, some final points here. Here's your best practices as an association going forward. Do these things. If you do these things now, you're going to be much better prepared to handle this new world of lending in condos. Meeting minutes. Definitely have the last year's worth, at least, of your meeting minutes from the board and the owners' meetings ready, and prepare to share those with the lenders. Reserve study. Get one. If you don't have one now, get it. If you have one, but it hasn't been updated in the last 3 years, definitely spend the money to get the update done. That's going to just take you so much further with these lenders, just to have that in your back pocket and say, here it is, we're on top of it. Budgeting, you have to inform your owners if you have upcoming maintenance. You need to adjust your budgets now and advise owners of upcoming increases so everybody can get prepared. And finally, special assessments. If you have one, put together all the documentation that's related to it. So what the special assessment is for, the proposals you got from contractors to form the basis for the special assessment, the reports, if you have engineers' reports that go along with that. Keep it all together, because that's the information you're going to want to include with your questionnaires. And that is all from my presentation. If anybody is still out there, I see as I was speaking, we had some issues, so let me know.
Everyone I have generically responded. I noticed also 5 to 10 of you have emailed / commented that you were having trouble with the connection. We're not sure why that is. We're just letting you know we're trying to solve it. I'm not sure we are going to have a solution, and we apologize for that. We've not had this issue arise before. Our questions we've answered, I think almost all the questions that were put in. I'm sure I've missed one or two, but we will get to those. If anybody has any questions, if you're still here and you send them to us, we will try. Here's one from someone says, will we be able to get an email with the presentation? I can't get unstuck. Oh, sorry about that. The answer is yes. We can send you the slides in a handout format so that you'll be able to see those. I see another question regarding the indemnity agreement that was attached to the program materials not being signed by the association, just by the unit owner and buyer. And could the association enforce it? The answer would be potentially as a third-party beneficiary. The idea is the association's not representing anything in the indemnity agreement and therefore would not necessarily have to sign it. I understand your concern. Our goal was not to create new liabilities for the association, but we can look at that one more closely. I think I don't know if I missed any. I'm looking down the list. Someone had sent us something indicating that they have ranch-style homes, significant landscaping and green space, ponds for retention, roadways, sanitary infrastructure, winter snow removal for roadways, drives, walks. It all adds up. And when I left the community, the realities, I would like to be able to compare with other communities and not ones that do not have the expenses to account for. I'm not sure what the question is. I'm not tracking, but maybe it's because I'm trying to read it quick. So this might be my problem. I would like to be able to compare with other communities and not ones that do not have those expenses to account for. So I think this individual is generically asking, is there a way to generically compare your records with somebody else's records? And I think the only answer would be probably through your property manager, if you could get various associations to agree to share information. Obviously, as the attorneys, we cannot do that without associations' consents, and no one's going to pay us to go get those consents. And I don't know another way to get them. This isn't about payment. This is about getting it. I think the property management company may be the way to start. Lydia, any thoughts on that?
No, I agree. I mean, I don't know how else you do that unless you have friends that live in neighboring associations. You can ask them and see what they share with you.
And then there's one that I want you to answer. There was a question. Has there ever been talk of a universal questionnaire? And by the way, I'm in favor of a universal questionnaire, but I don't know if you've seen anything on that. Go ahead.
I have not. I mean, I think, if Freddie Mac and Fannie Mae, who are both government agencies, can't come up with one, I'm not seeing that happening, but that would be great. I'm also in favor. I like things easier rather than harder.
Okay.
You see any other questions? I just got word from our internal folks that it looks like the recording may be fine. So maybe if we wrap it up here, we can submit the recording and everybody can at least hear what we had to say after the fact.
Yeah, we got one more comment. Someone's still having problems and cannot hear the questions and answers. We are so sorry for that. For those who can hear our presentation part, yeah, we're working on it. We will. I know I'm supposed to give the closing remarks, so I will do that. Give me 1 second. I've got to pull those over because I was answering questions. Sorry about that. So, for those of you who are part of the program, and we are really sorry about the technical problems, thank you for joining us today. We hope the information was helpful to you and your organization. We will do our best to get it out to you. As a reminder, this program is pending approval for Wisconsin Continuing Legal Education Credit and has been approved by Community Association Managers International Certification Board CAM ICB to fulfill continuing education requirements for CMCA certification. To report your CMCA hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. So we're hoping that will come through really clean. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. I'm going to guess one of the comments or make sure we don't have technical difficulties. We know that. We are doing our best. We apologize. I think that concludes today's presentation. Thank you very much, everyone. Bye.
Thank you.